If you don't know who Matthew Harris is, this is a very good breakdown of it. He was a professor. Well, he was like he was in his doctorate work at UCLA in philosophy, and basically had a mental break and started threatening to kill everybody, like everybody. And he had recorded himself being crazy and saying things. And there's 2 little clips of him saying stuff that are kind of weird and kind of funny.
Touchdown, paper, unbreaded.
So that's one of the things he was famous for saying: on paper, unbreaded. And this is another, gem of Matthew Harris here. This one's an interesting one because I don't think a lot of people have seen this clip.
To never be able to say the honest truth defeats the purpose. Do you like to be enslaved?
He also had some other comments here that are hilarious.
I don't let anyone determine the value of my own statements.
And Bifront says he made very valid points, honestly. Yes, in his 800-page manifesto known as Death Sentences, where literally just filled with racial and ethnic slurs, chat. I mean, it was really impressive. I know Nick used to read it. It was a hoot to read through at times, just based on what was going on. But yes, he lost his mind. And because of that, he got arrested by the feds. And arrested by the feds, he was facing multiple federal charges. He was sent away for a fairly long time to be medicated. And just recently, he was deemed competent to stand trial. Well, his defense attorneys came up with the strategy of trying him not guilty by reason of insanity. And that trial happened today. So in the lead up to that trial, we have a couple different things here. He waived his right to a jury trial under federal law. And, this is his. If you guys have never seen his autograph, if you guys wanted his autograph, you could find it on Pacer and you could print it out and put it on your wall. So he has a right to a jury trial under the 6th Amendment, and he's waiving it. So this is his waiver of a jury trial. We then get to, and this is a very unique thing here, because the right to have a jury trial or a bench trial is not always the same. In some states, it's entirely the decision of the defendant. For example, here in Ohio, it is the defendant's purview whether or not they have a bench trial or a jury trial. The prosecution gets no say in that. In some states, the prosecution has to approve of it. And then here, the feds made a joint recommendation. And they filed a joint motion for a bench trial. So, back in June of 2022, Harris filed a notice of insanity defense. In October, he filed for a competency hearing. In January of 2023, the competency hearing was held and the court made a preliminary finding of incompetency. So initially, he was not competent to stand trial. They sent him to the Federal Medical Center in Massachusetts for evaluation and treatment. On May 30th, they filed a joint notice and updating his situation. In the end of May last year, the court ordered them to file a status report. And by February, and it took this how long it took, the parties received the evaluation findings that he was now competent. It took a long time to medicate him and make him competent. And sometimes it does. Sometimes it takes a really long time to make people competent. Sometimes it takes a while to be restored. And that's the term. It's called competency that's get restored. So you're deemed incompetent but restorable. What happened from here? Well, they talk about what did the court do from there. So the court held a status hearing. They determined he was competent and could proceed to trial. So they extended the speedy trial clock to September 21st. And then the government also wanted to have him evaluated independently for the insanity defense. And that's what you get to do. If you make an argument that, hey, I was insane at the time, and here's a shrink that says I'm crazy and was crazy, the government gets to have one of their own shrinks evaluate and determine for themselves. They get to have their own opinion. Their own expert gets to look at you and determine whether or not you were insane at the time. And it was set to begin on September 10th with a 4-day trial to commence on September 16th. On July 11th, the government's evaluation was received. And now and because of that, they're asking for a bench trial. And what are they doing here? So they're setting aside a partial day on September 16th or 17th during the jury trial because they've made a decision and said, Your Honor, it's only going to take us a very little bit of time. And they talk about what they're going to do here and why they're doing this. The parties also asked to submit a stipulated set of facts that are agreed upon by both parties and proposed findings of fact and conclusions of law by August 12th. I've tried to look for these. They are under seal and restricted. We cannot look at them. Now, why would you stipulate to a set of facts? Well, remember, when you're challenging a case under not guilty by reason of insanity, you're not saying you didn't do it. You're basically agreeing with everything except that you were not in your right mind or able to know right from wrong or whatever standard of insanity you're using in that jurisdiction. Everything else is true. Everything else happened. You're not contesting that fact. So that's the difference here. And that's why they're doing a stipulated set of facts and they're doing proposed findings of fact and conclusions of law. They already know a bunch of the issues and they already have an idea of what they're trying to argue. And that's why they told the judge, we just need to narrow it down to the thinnest issue of was he insane at the time? Everything else has been agreed to. They point out the defense anticipates 2 exhibits, the 2 evaluations regarding whether he was insane at the time of the crime without objection by the government, an evaluation performed by a private evaluator the court doesn't have, and the evaluation that's already on the record. The government's not objecting to the admissions of these exhibits at the bench trial. The government will have no exhibits, and the parties do not anticipate calling witnesses. Think about that part, guys. They are not going to call witnesses. They're not going to call witnesses. Isn't that pretty interesting? How do you have a trial where you haven't called witnesses? You haven't offered evidence. Well, you offer exhibits, and you're stipulating to their admissibility, and you're already agreeing to stipulated facts. Well, you don't necessarily need a witness. You don't necessarily need everything that's going on there, right? I mean, that makes sense, chat. And it's kind of interesting. This is a very economical use of the trial court's time. If the court grants this motion, the parties will ask the court to make a determination on the existence of insanity at the time of the offense. The parties will not contest that the defense is able to meet their burden by clear and convincing evidence at the time of the commission of the acts constituting the offense. And that's notice that that's a very they further acknowledge that. And once again, guys, this is so interesting that they do this. I've never seen this before in a trial, like that they've all agreed to everything. It's pretty cool. They don't normally do this. And they say that they're pointing out that was Matthew Harris as a result of a severe mental disease or defect, unable to appreciate the nature and quality of the wrongfulness of his acts. The parties asked the court to make these findings pursuant to the federal rules of criminal procedure. And this is for the U.S. Attorney's Office right here. And then this is for Matthew Harris's attorneys. So the court had its hearing. And it had its hearing today. And here's what we get. So United States of America versus Matthew Harris. And this is the judge's conclusions of law and findings of fact. This is the judge's way of spelling out exactly on the record how she feels and why she feels about things. So on September 19th, the court considered the stipulations for a bench trial from the parties. The court also considered the 2 evaluations that were filed separately under restriction and whether or not he was insane at the time charged that the acts in the present case were committed. So the court adopts paragraphs 1 through 24 of the stipulations for bench trial. Once again, we don't have access to it. I can't download it, chat. I'm sorry. Which sucks, because I really want to know what they're stipulating to. The court finds by clear and convincing evidence that at the time of the commission of the acts constituting the offenses charged in counts 1 through 4 of the indictment, the defendant, as a result of a severe mental disease or defect, was unable to appreciate the nature and quality of the wrongfulness of his acts. The court finds the defendant not guilty only by reason of insanity of counts 1 through 4 of the indictment pursuant to 18 U.S.C. 4242. Now, once again, chat, we go through this. When you get found not guilty by reason of insanity, it's not over. It is not over. So what does this mean for him? Well, just because you did that, well, now the court has to do something with you because you're so crazy, in such a danger, you don't even know what you're doing. They can't just let you roam the streets. So as you can see, what's next? He's been committed to the custody of the Attorney General of the United States. You know, that's not a good ending. That's not a good ending. And it's further ordered the Attorney General of the United States shall hospitalize the defendant for treatment in a suitable facility and abide with the provisions of review and release set forth in 18 U.S.C. 4243. These provisions include whether the evaluation of whether it would create a substantial risk of bodily injury to harm to people of another due to the present mental disease or defect. So he's not out of the woods yet, chat. He's got, he could potentially be stuck in a mental hospital forever. I mean, that really sucks. And they explain to you what happens there because it's the hospitalization of an NGRI person. He shall be committed to a suitable facility as he's eligible for release pursuant to Part E. So, what's Part E say? He's going to be stuck for a while till they evaluate him. He doesn't just get to leave when he wants to. So he's going to have a hearing. And at that hearing, they're going to determine whether or not he's insane. And this hearing shall take place not later than 40 days following the verdict. So he's got 40 days, and they're going to make a determination on whether they keep him. And remember, with respect to any other offense, the person has the burden of proof by a preponderance of the evidence. So Matthew Harris has a preponderance of the evidence standard to get out. But if it's allegations of if there was serious damage to property or people, it's a clear and convincing standard. Remember, preponderance is just 51 to 49. If he had actually harmed someone, it would be this clear and convincing, which is like 66%. So thankfully for him, he's not completely screwed here. Stacy says, do we have a diagnosis? He does. We're not allowed to see it. All of this, if you go on Pacer and look at his case, guys, everything is under seal. Everything. And here, I'll show you real quick. Also, if you guys were not aware, his charges were threats in interstate commerce, false statement to a firearm dealer, and possession of ammunition by a prohibited person. But he also got charged with transmission of threats in interstate commerce. So if you guys notice, there are a lot of things you're going to notice here very quickly that start getting restricted document. And keep going, restricted document, restricted document, restricted document. Boom, boom. All these are restricted. I don't know. Like, there's all kinds of stuff we don't get to see. Restricted documents. So all the mental health evaluations, those would be private anyway. Those would not be something we could ever get to see. But a bunch of this is going to be restricted. There's more restricted psychiatric report. And he just keeps going. Look at this. All the restricted psychiatric report again. More restricted reports and documents. We don't get to see them. So that's it. We'll never know what happened to him. So he's going to be stuck in the mental hospital, guys. Like, it's at times it sounds good until it's better. It beats going to prison. I certainly don't disagree, but that's a heck of a way to go, man. That's a heck of a way to be dealing with this. So, good luck, Matt. Hope you can figure this out because I don't know how it's going to work. I don't know how it's going to work for you.